May it please the Court, my name is Patterson M. of Counsel. I appear for the accused, instructed by QUT solicitors. I respectfully submit that the record of interview be excluded on the grounds that there were substantial failures of police procedure from the time of my client's arrest until he was formally charged. I request Your Honour exercise your power under Section 130 of the Evidence Act 1977 to exclude this evidence. In the alternative, I seek Your Honour's consideration of excluding this evidence on public policy grounds in accordance with the principles established in Bunning and Cross. Using the principle of best evidence, I submit that this record of interview is not reliable because the police failed to comply with their obligations under the Police Powers and Responsibilities Act and the Police Powers and Responsibilities Regulation. On the day in question, my client, a 15-year-old Aboriginal boy, was taken into police custody at approximately 10 a.m, where he remained in a police car while the police conducted a search for 3 hours for further evidence. At approximately 1:45 p.m, he was taken to a police station, where he was advised that the Aboriginal and Torres Strait Islander Legal Service would be notified that he was in custody. I find no record that this call was made. No legal representation was provided to my client. At approximately 7:05 p.m, he was charged with murder after being 9 hours in police custody. Section 403, subsection 2 provides that a person must not be detained for more than 8 hours unless the detention period is extended by a magistrate or a justice of the peace. I have found no record that such a request was made. Section 403, subsection 4 of the Act provides that a person must not be questioned for more than 4 hours. On the facts provided, questioning of my client commenced at approximately 2 p.m. and ceased at 7 p.m. This equates to 5 hours of questioning. I respectfully submit that the police officers have failed to follow the requirements of Section 403 of the Act. The police have also failed to follow the procedures set out in Schedule 9, Section 35 of the regulations. My client's mother acted as his support person. However, I have been unable to ascertain if the police informed her of her responsibilities in the interview process. Essential to my client's situation, these instructions should have included ensuring that she understood who was being questioned and why. In addition, it is likely that she was advised that the Aboriginal and Torres Strait Islander Legal Service had been notified that her son was in custody. It is reasonable to expect that she then assumed that their absence meant that the matter was not substantial. I have also been unable to ascertain whether the procedures set out in Section 25 of Schedule 9 have been followed. This section requires the police to notify my client and his mother that he had a right to remain silent. The offer was also required to ensure that they understood what this requirement meant. My client ordinarily lives in Bamaga, which is a Torres Strait Islander community, and both my client and his mother are used to communicating in local dialects and English. It is recognised in the Supreme Court of Queensland Equal Treatment Bench Book that judicial proceedings can have negative effects on Aboriginal and Torres Strait Islander people that speak Aboriginal English. This means that it is likely that the police officers have misinterpreted some of my client's answers during the interview. Both my client and his support person would have a tendency to agree with any proposition put to them, especially by someone in power. This results in gratuitous concurrence. In the Crown and Bligh, it was determined that a 17-year-old Aboriginal boy's record of interview should be excluded because it was regarded as not voluntary. This was firstly due to the conduct of the police officer during the interview, secondly because he displayed gratuitous concurrence throughout the interview, and thirdly because the police officer ignored statements from Bligh that he would accept the charges to get the interview over with. The circumstances in Bligh are congruent with the situation of my client, and therefore my client's record of interview should not be regarded as voluntary. I respectfully submit that through the actions outlined, the police have shown a reckless disregard of the law. In the alternative, Your Honour, I respectfully submit that the discretionary exclusion on public policy grounds established in Bunning and Cross should be applied. I submit that the circumstances of this case support the discretionary exclusion because there are serious concerns about the reliability and unequivocalness of my client's statements. The cumulative effect of the various procedures that were omitted during the interview process indicate that the conduct of the police was a deliberate breach of the law. Additionally, there were no pressing circumstances for the police not to follow the procedures set out in the Act and the regulations. The purpose of the Act and regulations is to narrowly restrict the police in their exercise of their power. The actions of the police officers in question is in direct contravention with this purpose. In Pollard, Justice Dean said, "The weight to be given to public interest in conviction and punishment of crime will vary according to the heinousness of the crime and the reliability and unequivocalness of the alleged confessional statement. My client has been charged with murder, which we all appreciate is extremely serious. However, the manner in which the interview was conducted calls into serious doubt the reliability of any statements. As Justice Dean qualified in Pollard, it is not usual practice to exclude a voluntary statement in a serious matter such as murder. However, deliberate or reckless disregard by police of statutory obligations can lead to the evidence being unfair for the accused and therefore excluded on public policy grounds. I submit, Your Honour, this is such a case."